All right, welcome to Brown Act 101 training. I'm your City Attorney, Alisha Patterson. The Self-M Brown Act is California's open meeting law. It has been in place for more than half of a decade, adopted in 1953, and it is codified in California Government Code, Section 54950 et sec. If you're interested in learning more about the Brown Act and what we can provide in this quick 5-minute training, then I would highly recommend you look at Attachment A to the Elected and Appointed Officials Handbook. It is the League of California Cities Brown Act guide, and it's very, very useful and very user-friendly. This slide shows the intent and declaration of the Brown Act. In a nutshell, it's that your actions as commissioners, council members, or committee members be taken openly in public, where the public can watch your deliberations. And to quote, "The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is good for them not to know. The people insist on remaining informed so that they may retain control over the instruments that they have created." Back when the Brown Act was adopted, it was meant to prevent basically backroom deals or decisions from being made out of the public view. It has evolved over time to apply to all sorts of different places where meetings or discussions or deliberations might occur, which include the virtual world, like social media, emails, or offline in places like parking lots, social situations, before and after meetings start. Basically any situation where you have an opportunity to have discussions with your colleagues on the council, commission, or committee. I'm going to start with some terminology that I'll be using throughout the presentation. The first term you need to know is legislative body, and in the Brown Act, that is defined as any group created by ordinance, resolution, or formal action of a legislative body. So that includes the city council itself, all of the commissions, the mayor's emergency preparedness ad hoc, and certain joint meetings. The next term you need to be familiar with is quorum, which is a simple majority of the members of the legislative body. So in the case of the city council, that would be 3 of 5 members. In the case of commissions, that would be 4 of 7 members. And for the case of the emergency preparedness ad hoc, that is 8 of 15 members. There are certain groups that do not qualify as a legislative body under the Brown Act, but they need to meet all of the criteria listed in these bullet points. So first, they need to be purely advisory, not decision-making. They need to be composed solely of members of the legislative body. They must be less than a quorum or majority of the legislative body. They cannot have continuing subject matter jurisdiction, or in other words, cannot be a standing committee. They cannot have a fixed meeting schedule, and they cannot have been created by formal action of a legislative body. So some examples of groups that do not qualify as a legislative body under the Brown Act would include 2 members of the city council, which is a 5-member body, who are meeting to discuss a development project with each other. It's very common for the city council to sort of break off into what we've started to call Brown Act buddies, or pairs, so that they can discuss issues offline. Another example would be an advisory ad hoc committee that's composed of no more than 3 members of a 7-member commission, such as the Planning Commission, and it would need to be unilaterally appointed by the chair of the Planning Commission rather than formed by an action of the Planning Commission as a whole to study a discrete issue. It's something that doesn't have continuing jurisdiction and doesn't have a fixed meeting schedule. And then in the case of the emergency preparedness ad hoc, it would not be a legislative body if up to 7 members of the 15-member ad hoc committee met to discuss an item or met for a site visit or something of that nature. Another type of meeting that is specifically defined in the Brown Act is a serial meeting, which differs from a meeting in that it doesn't always take place in the same time and location, and it's done through a series of communications, such as conversations, emails, text messages. It could also be done through social media posts, and it can be done either directly by members of the committee or commission or done through intermediaries. Otherwise, it is defined exactly the same as a meeting. It just is something that can either happen through sometimes like a game of telephone, or other times like a spoken wheel where an intermediary is going from member to member to try to get consensus or try to discuss an item. So now that we've gone over terminology, we can go over some of the key Brown Act requirements. This is not an exhaustive list, but it's what you should know in a brief primer on the Brown Act. The first is that all of the meetings of a legislative body need to be open to the public. What that means is the public needs to be able to physically attend the meetings in the same location where the meetings are being held. It's up to the city on whether to also allow virtual attendance and or participation in the meetings. And in Claremont's case, Claremont's practice is to allow virtual attendance, but not virtual participation. The second requirement you should be aware of is that the city is required to publish an agenda before every meeting. And for regular meetings, those agendas need to be posted 72 hours in advance. For special meetings, the agendas need to be posted 24 hours in advance. The purpose of the agenda is to disclose every topic that the legislative body is going to discuss at the meeting. One common pitfall of the Brown Act is that during meetings, a council, commission, or committee will stray from the agenda and start to discuss something that was not agendized. This is a Brown Act violation, but it's very common, and it's something that can happen for a variety of reasons. My suggestion, if you start to see this happening when you're in a meeting, is to call a point of order and ask for clarification if the discussion you're having is within the scope of the agenda item. Another requirement of the Brown Act is that the legislative body needs to allow the public to comment on every item that is posted on the agenda. And the public needs to be allowed to provide their comments either in writing or verbally or both. And in Claremont's case, members of the public can submit written comments basically at any time, including during the meeting, although that is not necessarily very effective. And they are allowed to provide verbal comments in person at the meetings. For verbal comments, the legislative body is allowed to impose time limits, but the time limits need to be uniform. And in Claremont, the default time limit for verbal comments is 3 minutes per comment. The commission or committee or council could choose to make that time limit longer or shorter as long as it's uniform for every speaker. And lastly, as long as a comment relates to the agendized item, the legislative body needs to allow it even if the comment is offensive or profane. One way to avoid Brown Act violations on social media is to be vigilant of who else on the committee, commission, or council is interacting with the post, and making sure that if other members of your committee, commission, or council have already weighed in, that you don't weigh in as well. And so I like to use this example that council member, then Mayor Pro Tem Ed Reese, used as a response when somebody was asking for his input on a social media post. He replied very politely, "Hi Sandy, Brown Act rules do not allow more than one council member to comment or provide an opinion online to a potential council item. Since Councilmember Jennifer Stark has already commented, I would be happy to have a conversation offline. Please email me," and then he provided his address. This is a really good way to continue to engage with the public without creating an inadvertent Brown Act violation. Another way to avoid serial meetings, either through the game of telephone daisy chain or social media, is to always check for a quorum before you personally engage in the conversation. My recommendation is, just as a best practice, to avoid interacting with each other's social media posts on topics that are within your legislative body's purview. And again, always be very, very careful before hitting reply all on messages that are sent to you in your capacity as a member of the legislative body. If you're put in the position where a well-meaning intermediary seems to be gathering consensus and telling you what your colleagues on the legislative body are thinking, one way to respond to this is to just let them know that even though you're happy to have a one-on-one discussion, that you're not able to talk about what the other members of the legislative body have told you. So to wrap up, a few takeaways from Brown Act 101 training. First, don't discuss the business of your legislative body outside agendized meetings. There are a handful of exceptions. You are able to talk about business with city staff. You will have liaisons for your commission, committee, or council who are able to discuss items with you. You're also able to discuss items with members of the community as long as they're not acting as intermediaries in creating serial meetings. And if you want to, you can discuss business with less than a quorum of your own legislative body, but again, you need to be careful to make sure that the members that you're having those discussions with aren't having discussions with other members and creating a serial meeting. Second, takeaway is that at meetings you need to be careful to stick to items on the agenda and call a point of order if you think you're straying from the agenda. And last but not least, be very careful to avoid Brown Act violations via email, text message, and social media. And that concludes the Brown Act training. If you have questions, please do not hesitate to contact your staff liaison.